When can you sue the government? See, what started out as an erroneous credit report filing has turned into the heart of the question brought before the Supreme Court in the case Department of Agriculture, Rural Development, Rural Housing Service versus Kurtz. What the court found and how it got there points to a serious flaw in the constitutional education of lawyers and judges throughout this nation. So we'll look at that next on the Constitution Study.
Neighbors and have a few good friends. Every day we're everyday Americans. Oh, every day we're everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study, where we read and study the Constitution. Teach your generation be free, and I'm glad you could join me today. It's one of those foundational assumptions, the foundational statements that literally changes our understanding of government. It's this idea of sovereign immunity, and that's what the case is about. Before we go there, though, if you want to find out more about this case and others that we're working on, well, head to the website constitutionstudy.com and sign up for one of the mailing lists. I'll talk more about the website at the end of the episode, but for now, let's talk more about this USDA versus Kurtz and the question of sovereign immunity. Although not at the heart of our story, this begins with a simple violation of the Constitution. This case arises from a loan Reginald Kurtz secured from the Rural Housing Service. The service, a division of the United States Department of Agriculture, issues loans to promote the development of safe and affordable housing in rural communities. The Constitution does not authorize the United States to issue loans for any reason. As the 10th Amendment states, the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. This may seem like a trivial thing, but if Congress had not passed legislation to allow agencies to loan money, then Mr. Kurtz would not have had the problems that led to this case. Yes, Mr. Kurtz's problem began after he paid off the loan, but that's not at the heart of the case. According to Mr. Kurtz, he repaid his loan in full by mid-2018. Despite this, the USDA repeatedly told TransUnion, a company engaged in the business of preparing consumer credit reports, that his account was past due. These misrepresentations damaged his credit score and threatened his ability to secure future loans at affordable rates. In an effort to resolve the problem, Mr. Kurtz alerted TransUnion to the error, and the company in turn notified the USDA. But Mr. Kurtz says the USDA failed to take any action to investigate or correct its records. So he eventually decided to sue the agency under FCRA. Yes, any lending firm could have erroneously reported past due a loan that had been paid in full. And any lending agency could fail to take action to resolve the error, which could lead to a lawsuit. In this case, Mr. Kurtz sued under the Fair Credit Reporting Act. According to his complaint, the USDA furnished information to TransUnion. The agency had noticed that the information it supplied was false. That false information impaired Mr. Kurtz's ability to access affordable credit, yet the agency failed to take any steps to correct its mistake, either willfully in violation of Section 1681N or negligently in violation of Section 1681O. By way of remedy, Mr. Kurtz sought money damages consistent with what FCRA allows. Mr. Kurtz's complaint seems simple enough. The lender, the USDA, had been notified that the information it provided to credit reporting service TransUnion was false and either negligently or willfully refused to correct its mistake. For this violation of the law, Mr. Kurtz sought monetary damages. The response from the USDA is when Mr. Kurtz's issues went from bad to worse. In response, the USDA moved to dismiss the complaint. The agency did not dispute that allegations like Mr. Kurtz states a viable claim for relief. Instead, it pointed to this court's precedent holding that, as sovereign, the federal government enjoys immunity from suits for money damages unless Congress waives that immunity. The USDA did not dispute the fact that Mr. Kurtz had a viable claim. They simply claimed, you can't sue us, we're the government. Notice that the USDA did not claim they had immunity based on constitutional or even statutory argument, but because the court had previously said so. Now, what is this sovereign immunity the USDA is claiming? Well, from the Free Legal Dictionary, we find sovereign immunity is a judicial doctrine that prevents the government or its political subdivisions, departments, and agencies from being sued without its consent. The doctrine stems from the ancient English principle that the monarch can do no wrong. Did you catch that? This whole sovereign immunity comes from the idea that the monarch, the sovereign, can do no wrong. This is exactly what we tried to get away from in 1776. Read the Declaration of Independence and count how many times they complained that the king could do what he wants. There were no consequences for the monarch because they believed he could do no wrong. This, of course, was because the king was sovereign, which the Free Legal Dictionary defines as a chief ruler with supreme power, one possessing sovereignty. It's also applied to a king or other magistrate with limited powers. What about here in the United States? Well, the Free Legal Dictionary goes on to state, in the United States, the sovereignty resides in the body of the people. That means the government is not the sovereign, and therefore does not have sovereign immunity. Now, that hasn't stopped federal courts at all levels from pretending they do. Rather, courts have argued about whether or not Congress had waived said immunity in the Fair Credit Reporting Act. Yet the lower courts have reached different views on the question of whether federal agencies are answerable under FCRA for their mistakes. Like the Third Circuit, the Seventh and D.C. circuits have held that FCRA authorizes suits against government agencies no less than it does private lenders. The Fourth and Ninth Circuits, by contrast, have held that sovereign immunity bars consumer suits against federal agencies. We agree to hear this case to resolve that conflict. While the Supreme Court notices that the circuit courts are split, it's not on the question of sovereign immunity, but whether Congress had waived said immunity under FCRA. Now, the court gave a unanimous opinion written by Justice Gorsuch. The executive branch may question the wisdom of holding federal agencies accountable for their violations of the Fair Credit Reporting Act. Certainly, the many and resourceful arguments it advanced today suggest as much, but Congress's judgment commands our respect, and the law it has adopted speaks clearly. A consumer may sue any federal agency for defying the law's terms because it faithfully followed this legislative direction. The judgment of the Court of Appeals for the Third Circuit is affirmed. While I admire the court for respecting the acts of Congress, I point to a superior law they completely ignore in this opinion, that the United States has limited and enumerated powers, and that among those powers delegated to it, the power of sovereign is not one of them. From the 10th Amendment, we read, "The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people." Furthermore, that when the justices took office, they were required to swear or affirm they would support the Constitution of the United States, Article 6, Clause 3, which reads, "The senators and representatives before mentioned, and the members of the several state legislatures, and all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution." As such, the court should have found for Mr. Kitts not because Congress said the people could sue under FCRA, but because no federal branch, department, or agency has sovereign immunity. There was plenty more in the opinion of this case, but in my estimation, it's pure distraction. The federal courts at all levels agreed that the United States has sovereign immunity, even though that is not a power delegated to it in the Constitution. There was not a single point in the opinion about sovereign immunity being constitutional, yet they still uphold it. How could that be? For years, I've asked those who have attended law school a simple question. When you were in law school, did you study the Constitution or constitutional law? In the 4 to 5 years I've been asking that question, I've had exactly one person tell me they studied the Constitution in law school. The supreme law of the land is not studied in law school? The document that every government official is required to swear or affirm they will support is not studied in law school? This is the fundamental and abject failure in our legal education system. I doubt a single judge or justice who has heard this case actually studied the Constitution in law school. That explains why the very men and women who took an oath to support it placed the opinions of judges above the supreme law of the land. Although Mr. Kurtz got the outcome he wanted, which was to be allowed to sue the USDA, This is the reason why this case is actually a further corruption of our judicial system. Think about this for a second. Mr. Kurtz was allowed to petition the government for a redress of grievance, a right protected by the First Amendment. However, Congress can allow federal agencies to violate the law without concern that they may be sued based on this false idea from some court that the government is sovereign but not the people. Is any of this different than some of the grievances we had against King George? From the Declaration of Independence, he is combined with others to subject us to a jurisdiction foreign to our Constitution and unacknowledged by our laws, giving consent to their acts of pretended legislation, for protecting them by a mock trial from punishment for any murders which they should commit on the inhabitants of these states, for depriving us in many cases of the benefit of trial by jury, for taking away our charters, abolishing our most valuable laws, and altering fundamentally the forms of our government. Saddest of all, neither the judges, justices, attorneys, nor parties to this case seem aware of the fundamental coup d'etat this represents. It's the destruction of our Constitution and a fundamental alteration of our form of government. Sometimes people ask me why I focus on these fundamentals when that's not how the world works. Well, the answer is simple. If the world is wrong, then we should change it. If the Constitution has been superseded by the opinion of a bunch of black-robed high priests, then they're wrong, the Constitution is right, and if we don't stand up and say something, well, the country's lost. For decades, we've not stood up and said something, and we've been losing the country because of it. Now we're to the point where the government thinks, hey, I can do whatever I want because nobody can sue me because a judge said so. What happened to we the people? What happened to a government of, by, and for the people? What happened to the idea, the fundamental idea of self-governance? It's gone. And it's gone not because we got rid of it, it's because we ignored and continue to ignore when it is violated. If Congress can say, hey, we can violate the First Amendment and you can't sue us because we said so, where's your First Amendment protections? If a court can simply say, yeah, they did wrong, they broke the law, but now you can't sue them, they're the government. See, the fundamental understanding, the fundamental principle of the United States is sovereignty is held by the people. That's why the constitutions of most of our states acknowledge that all power is inherent in the people. This idea of sovereign immunity is a complete upending of that. It places sovereignty in government, not the people. We are no longer the free if judges can say whether or not we're free. This, ladies and gentlemen, is one of those cases that will probably be swept under the rug. Most people won't pay much attention to it. You won't hear it on the nightly news. You won't hear it. You won't read it in your newspapers. But this is a classic example of the coup d'etat, the overturning, the nonviolent insurrection against the Constitution of the United States. And it wasn't done by a group of people on January 6th, and it wasn't done on the streets of some city. It was done in the halls of the Supreme Court by a group of black-robed apparatchik that believe they can do whatever they want, and everyone else has to dance to their tune. Now, if you want to learn the truth, well, check out the website constitutionstudy.com. You'll find this and other videos, articles, links where I provide data, evidence, proof of what I'm saying is true. Educate yourself, and then learn how to defend and assert your rights, and start locally. Don't worry about Washington, D.C. yet. Washington, D.C. is a cesspool. Start with your own backyard. If you want to learn more, well, check out our Patriots program. Just click the button for Patriots or go to constitutionstudy.com/patriots. Check it out. Try the boot camp. It's absolutely free for the boot camp. And if you pass the boot camp, well, you'll be invited to join us as a patriot, learning to protect your rights, learning to defend the rights of others, and then learning how we can return this nation of ours to the land of the free because we are the home of the brave. And if you like that, Well, I hope you come back and join us next time for the Constitution Study.